What's going on, YouTube? Listen up, young elder gang. This is Billionaire Ted Strokes at you with another banger. Please make sure you like, subscribe, and share this video, fam. I hope this video get at least 100,000 likes. In this video, you will find history, definitions, scripture, information, and best of all, what we Americans have been deprived of from the beginning, the truth. Keep in mind, this content used in this video is intended for entertainment, educational, and informational purposes only. The information provided on this video is not to be construed as legal advice. We are not legal attorneys. For legal advice, please seek out a licensed legal advisor or attorney. We will give you the total truth as we best understand it today. Be sure to hit that like button, young elder gang. Hit that subscribe button if you're new to the channel. Hit that bell and don't forget to check back with us every day for new content. All right, let's get started. Are you ready to dive into the dramatic world of ancient Roman law? Strap in, because this ride is wild. Roman law, the bedrock of many modern legal systems, dates back to 753 BCE. Imagine a mix of written and unwritten rules from assemblies, Senate resolutions, emperor decrees, and praetor edicts. Sound complicated? That's because it was. Some key principles from Roman law include innocent until proven guilty, the use of written contracts, and the right to a fair trial. These concepts are still alive and kicking in today's courtrooms. Take the 12 tables, for example. Inscribed on bronze tablets, they covered everything from debt and trials to family rights and public law. One law even dictated that speaking false witness could get you tossed from the Tarpeian Rock. And let's not forget about the Roman crucifixions. The Romans perfected crucifying for 500 years until it was abolished by Constantine I in the 4th century AD. Crucifixion in Roman times was applied mostly to slaves, disgraced soldiers, Christians, and foreigners, only very rarely to Roman citizens. Examples of crimes that were punished with crucifixion include murder, theft, treason, slave rebellion, religious transgressions, and more. Also, sometimes military generals would crucify their enemies. Talk about harsh penalties. Sounds like the Code of Hammurabi, right? And let's not forget the Lex Canuleia, which allowed intermarriage between patricians and plebeians, or the Lex Oppia, which limited women's adornment. Roman law wasn't just about order, it was about defining society. This is about to be a good law lecture. Ancient Rome's legal law system is a good place to start your studying if you're in law school. The Roman laws is what this law system is based on now. Now let's go more into some Roman laws. We have reason to believe that Roman laws are a combination of the Code of Hammurabi, the 42 laws of Mott, the Mosaic Code of Laws, plus tweaks and upgrades were made as times went on, based on the society developments. Roman law has a history nearly as old as Rome itself. In the early days of the Republic, Roman law was held in the minds and memories of Rome's judges and magistrates. Such a system was prime for abuse. A magistrate could forget or even change laws on a whim, and there was no way to question him. So since magistrates were aristocrats, or patricians as the Romans called them, the common people, or plebs, had little hope at finding justice in such a system. The plebs protested this injustice system for many years until at last in 450 BCE, Roman law was codified and written down on the famous 12 tablets of Rome. The written law guaranteed that all, high as well as low, were subject to the laws of Rome. As the years went by and the Republic matured and became more inclusive, the Roman legal system was reformed to accommodate these changes. The ruling of judges began to be used as precedent for future cases, as did the Edicts of Praetors. The Roman Republic was a period in ancient Roman history where the city-state of Rome was governed by a republican system, lasting from approximately 509 BC until 27 BC, when it transitioned into the Roman Empire. It marked a time when power was not held by a single king, but instead was shared among elected officials and the Senate, with citizens having a degree of political participation. The Roman Republic was the era of classical Roman civilization, beginning with the overthrow of the Roman kingdom, and ending in 27 BC with the establishment of the Roman Empire following the War of Actium. Citizenship in ancient Rome was a privileged political and legal status afforded to free individuals with respect to laws, property, and governance. Citizenship in ancient Rome was complex and based upon many different laws, traditions, and cultural practices. Roman law, like other ancient systems, originally adopted the principle of personality, that is, that the law of the state applied only to its citizens. Foreigners had no rights, and unless protected by some treaty between their state and Rome, they could be seized like ownerless pieces of property by any Roman. It has been said that law and order is Rome's biggest export. As the Roman Empire expanded, the Roman imposed their legal system, laws and rules on the territories that they conquered. Feuding nations one by one fell into the fold of the Pax Romana, or Roman peace. The Pax Romana is a roughly 200-year-long period of Roman history which is identified as a golden age of increased and sustained Roman imperialism, relative peace and order, prosperous stability, hegemonic power, and regional expansion. This is despite several revolts and wars and continuing competition with Parthia. Since they refused to worship the Roman gods, the Romans killed about 1 million Jews. They tortured them to death. This shows that the Pax Romana was not all that peaceful. The Pax Romana had many positives and many negatives. During the so-called Pax Roman, the Mediterranean entered an era of peace and prosperity that lasted, like we said, about 200 years. The Edictum Praetoris, or Praetor's Edict, was a yearly declaration of principles in ancient Roman law. It was issued by the Praetor Urbanus, the elected magistrate responsible for administering justice in Rome. The edict outlined the praetor's intended actions for their term of office and had the force of law. Shaped Roman law, the edict was a major factor in shaping and adapting Roman law over time. Guided judges, the edict provided judges with principles to follow when deciding cases. Developed private law, the edict of the urban praetor was especially important for the development of private law. Promised new actions, the edict allowed the praetor to promise new actions and remedies, creating new rules. The edict was written on a whiteboard or album and displayed in a public place. The sections were outlined in red, a color known as rubricae. Jurists would often sit by the edict, offering advice to potential clients. The edict was valid for the term of the praetor who issued it, but the new praetor would usually take over the previous edict, making any changes they desired. This is known as Edictum Praetoris. During the early empire, the praetor's edict was revised to become the Edictum Perpetuum. A Praetorian edict was a proclamation issued by a praetor, a magistrate in ancient Rome, at the start of their term. It explained the grounds on which a formula or legal action would be granted. This edict had the force of law and was important in shaping the principles by which the praetor would act in office. Simultaneously, philosophical ideals from Stoicism found their way into Roman law. These reforms did not stop with the death of the Republic and the rise of the Principate. The Principate was the form of imperial government of the Roman Empire from the beginning of the reign of Augustus in 27 BC to the end of the crisis of the 3rd century in AD 284, after which it evolved into the Dominate. Roman emperors, struggling to deal with the new challenges of the growing empire, would often appoint imperial jurists to refine and interpret law. Jurists were a professional group of legal experts who emerged in the 3rd century BCE to interpret and provide opinions on Roman law. They also advised magistrates, helped draft edicts, and produced legal punishments. The work of jurists like Gaius, Ulpian, and Paulus is considered to have been central to the development of Roman law during the classical period. Imperial jurists is where the law games begin. This is like the first lawyers of Rome. Imperial jurists may refer to jurists in ancient Rome or to the idea of an imperial judiciary in the United States. The term imperial judiciary refers to the idea that one branch of the government, in this case the judiciary, is gaining too much power at the expense of other branches and society. Some say that the judiciary has gained a lot of power in recent decades and that it has been given too much additional power. Others argue that the judiciary is a reactive institution that is limited in its power because it can't initiate action on its own. After Constantine, Roman law continued to evolve in a number of ways. Justinian's Code, Emperor Justinian commissioned a compilation of all existing Roman law into one body of work, which is sometimes called Justinian's Code. This compilation was a major codification of laws and is considered one of the emperor's greatest contributions to Western society. Byzantine law, after Justinian's reign, Roman law continued in the Eastern Roman Empire, which became known as the Byzantine Empire. Byzantine law was influenced by Orthodox Christianity and Hellenism and was based on Justinian's Corpus Juris Civilis. Roman law in Western Europe. Roman law remained in use in Western Europe until the end of the 18th century. It was the basis for the law codes of most countries in continental Europe and influenced the development of law in other parts of the world. English and Anglo-American common law. Roman law also influenced English and Anglo-American common law, particularly in their Latinate legal glossary. Rediscovery of Justinian's Code. In the 11th century, manuscript copies of Justinian's compilation were rediscovered, which led to a revival of Roman law in Europe. This rediscovery inspired the medieval university and the scholastic method. The First Council of Nicaea in 325 AD led to many changes in Christianity, including the establishment of canonical laws and the affirmation of the doctrine of the Trinity. Calendar. The council rejected the Jewish calendar for celebrating Easter. Clergy. The council prohibited clergy from self-castrating, lending money at interest, and moving from one church to another. It also established a minimum term for catechumens and required bishops to be ordained in the presence of at least 3 provincial bishops. Bishops. The council confirmed the primacy of Alexandria and Jerusalem over other sees in their respective areas. Trinity. The council affirmed the doctrine of the Trinity, which states that Jesus is the second person of the Trinity, along with the Father and the Holy Spirit. Heresy. The council exiled Arius, 2 bishops, and Constantine for heresy. The council also linked secular and ecclesiastical powers in Europe for the rest of antiquity and the Middle Ages. Following the Nicene Council, Roman laws saw a shift towards solidifying the position of Christianity within the empire, including measures like prohibiting the persecution of Christian converts, granting legal protections to the Church, and potentially limiting the public practice of paganism. As the Roman Empire increasingly embraced Christianity under the leadership of Constantine the Great, this also led to changes in regulations around the clergy, including restrictions on their behavior and the process of ordination. Key points about the changes in Roman law after the Nicene Council. Religious freedom for Christians. The most significant change was the official recognition of Christianity and the end of persecution against Christians, which was facilitated by the Edict of Milan issued by Constantine before the Nicene Council. Church authority. The council established a hierarchy within the church, granting more power to bishops and defining the authority of the church leadership. Clergy regulations. Laws were implemented regarding the conduct of clergy, including restrictions on their behavior and the process of ordination, potentially addressing issues like self-castration or improper conduct. Doctrine enforcement. The Nicene Creed, established at the council, defined key Christian doctrines, including the divinity of Christ, which would be enforced through legal means against those who deviated from the established beliefs. Limited pagan practice. While not a complete eradication, there may have been legal measures taken to restrict public pagan practices as the empire moved towards Christianization. The Pope is considered one of the world's most powerful people due to the extensive diplomatic, cultural, and spiritual influence of his position on both 1.3 billion Catholics and those outside the Catholic faith, and because he heads the world's largest non-government provider of education and healthcare with a vast. As a legal system, Roman law has affected the development of law in most of Western civilization as well as in parts of the East. It forms the basis for the law codes of most countries of continental Europe, see civil law, and derivative systems elsewhere. The Pope has a significant influence on Roman law, primarily through the development and interpretation of canon law, which governs the Catholic Church, shaping legal principles related to marriage, family matters, inheritance, and religious practices, particularly in countries with a strong Catholic presence, essentially acting as a moral authority that can impact legal interpretations in these areas. Key points about the Pope's influence on Roman law. Canon law. The Pope, as the head of the Catholic Church, has the authority to issue decrees and interpretations of canon law, which directly affects the legal landscape within the Church and can influence secular law in Catholic-majority regions. Moral authority. Even when not directly dictating legal statutes, the Pope's moral authority can sway legal decisions on issues related to ethics and social conduct. Historical context. Throughout history, the papacy held significant political power in Rome and surrounding areas, further contributing to the integration of church law with legal systems. Vatican City State. As the head of State of Vatican City, the Pope has full legislative and judicial power within the Vatican, providing a model for legal systems based on Catholic principles. The Sabinian School was one of the 2 important schools of law in Rome during the 1st and 2nd centuries CE. The Sabinians took their name from Masurius Sabinus, but later were known as Cassians after Sabinus's student, Cassius Longinus. The school was founded by Gaius Ateius Capito, a conservative jurist during the reign of Augustus. The school was named after Mesurius Sabinus, a leader of the school. The Sabinians were rivals with the Proculeian school, which was named after Proculus. The schools were involved in many controversies, but it's difficult to determine their underlying principles. The Sabinians were generally conservative in their legal views. Salvius Julianus was the most famous head of the Sabinian School. Mesurius Sabinus's work, Mesurius Sabinus's 3-volume treatise on civil law, was influential and was commented on by later jurists. So, the legal system primarily dealt with private rather than public law? How would the Romans have defined the rule of law? The rule of law is a political ideal that all people and institutions within a country are subject to the same laws, including leaders and lawmakers. It's often summarized as, "no one is above the law." The rule of law is a core element of the United Nations human rights and humanitarian agendas. It's also a foundation for democracy and good governance, and it's necessary for inclusive economic growth. The rule of law requires that laws are publicly promulgated, equally enforced, independently adjudicated, and consistent with international human rights principles. The Supremacy Clause is a constitutional principle that establishes the federal government's laws, treaties, and constitution as the supreme law of the land. This means that when state laws conflict with federal laws take precedence. The Supremacy Clause is found in Article 6, Paragraph 2 of the U.S. Constitution. It allows the federal government to create a central bank, enact legislation, and enforce treaties. The Supreme Court has used the Supremacy Clause to establish the federal government's role in managing the nation's affairs. For example, in the 1824 case Gibbons v. Ogden, Chief Justice John Marshall ruled that federal coastal licenses superseded a state law that gave a steamboat company a monopoly. The Supremacy Clause is a founding principle in U.S. constitutional law. It designates the Constitution as the supreme law of the land. This generally means that when state laws conflict with the Constitution wins. The Code of Justinian, also known as the Codex Justinianus, was a collection of laws and legal interpretations created by Byzantine Emperor Justinian I. The code was a rationalization of hundreds of years of Roman law, eliminating contradictions and conflicts, and repealing any laws not included. The code included past laws, extracts from Roman jurists, an outline of the law, and new laws created by Justinian. The code covered a wide range of topics, including marriage, property, crime, adoption, slavery, business, and trade. The code was completed in stages over a period of years. Codex Constitutionum, the first book, which began in 527. Digesta, the second book, which was created between 530 and 533. Institutiones, the third book, which was compiled and published in 533. Novellae Constitutiones Post Codicem, the fourth book, which was completed after Justinian's death in 565. Significance: the Code of Justinian is part of the Corpus Juris Civilis, which also includes the Digest and the Institutes. The Novellae Constitutiones is also considered part of the Corpus Juris Civilis, even though it was compiled after Justinian's death. The Magna Carta, signed by King John of England in 1215, is an example of a document that helped to establish the rule of law. Article 39 of the Magna Carta stated that the life, liberty, or property of free subjects could not be taken away arbitrarily. Magna Carta Libertatum, commonly called Magna Carta, or sometimes Magna Charta, is a royal charter of rights agreed to by King John of England at Runnymede near Windsor on the 15th of June 1215. Magna Carta was issued in June 1215 and was the first document to put into writing the principle that the king and his government was not above the law. It sought to prevent the king from exploiting his power and placed limits of royal authority by establishing law as a power in itself. The Magna Carta is a document written in 1215 that limited the power of the English king. It remains important today as a symbol of protest against authoritarianism. In 1215, when King John confirmed Magna Carta with his seal, he was acknowledging the now firmly embedded concept that no man, not even the king, is above the law. That was a milestone in constitutional thought for the 13th century and for centuries to come. The Magna Carta dealt mostly with the rights of barons and the Roman Catholic Church. However, it also guaranteed the rights of women and children who inherited property. It stated that a person could not be punished for a crime unless they were lawfully convicted. Common law is a legal system based on judicial precedents and case law rather than formal legislation. It's also known as judge-made law or judicial precedent. Common law is used when the outcome of a case can't be determined by existing laws and is often used to inspire new legislation. Common law is the body of law created by judges and similar quasi-judicial tribunals by virtue of being stated in written opinions. The defining characteristic of common law is that it arises as precedent. Common law courts look to the past decisions of courts to synthesize the legal principles of past cases. Here are some characteristics of common law. Unwritten. Common law is a body of unwritten laws. Based on precedent, common law is based on legal precedents established by courts in similar cases. Influenced by judicial authorities and juries. Common law is influenced by the opinions and interpretations of judicial authorities and public juries. Adversarial system. Common law functions as an adversarial system where two opposing parties argue before a judge. Judge-determined sentence. The judge determines the appropriate sentence based on the jury's verdict. Common law originated in the English courts after the Norman conquest in 1066. It was once the predominant way of governing society, especially in the early United States. Today, common law is practiced in many countries, including the United States, Canada, Australia, India, and New Zealand. Private law is that part of a civil law legal system which is part of the jus commune that involves relationships between individuals, such as the law of contracts and torts, and the law of obligations. The laws of the 12 tablets was the legislation that stood at the foundation of Roman law. Formally promulgated in 449 BC, the tablets consolidated earlier traditions into an enduring set of laws. In the Forum, the 12 tablets or tables stated the rights and duties of the Roman citizen. Private law is a branch of law that regulates the interactions between individuals, businesses, and organizations. It covers a wide range of topics, including contracts, torts, property, family law, commercial law, intellectual property, unjust enrichment, restitution, equity, and remedies. Private law is different from public law in several ways, including the purpose of private law is regulating interactions between individuals and organizations, while public law protects individuals' rights and maintains social order. Enforcement. Private law is enforced more individually, with the aggrieved party addressing violations in civil courts. Application. Public laws are intended for general application, while private laws are enacted for the benefit of a specific individual or small group. An example of private law is when the creator of a copyrighted work sues someone for using their work without permission. What does publicly mean in law? A exposed to general view indecency known or recognized by many or most people, of relating to or affecting all of the people or the whole area of a nation or state statutes. Public law is the part of law that governs relations and affairs between legal persons and a government, between different institutions within a state, between different branches of governments, as well as relationships between persons that are of direct concern to society. Public law comprises constitutional law, administrative law, tax law, and criminal law, as well as all procedural law. Laws concerning relationships between individuals belong to private law. The distinction between public and private law was first made by Roman jurist Ulpian, who argues in the Institutes, in a passage preserved by Justinian in the Digest, that public law is that which respects the establishment of the Roman Commonwealth, private that which respects individuals' interests, some matters being of public and others of private interest. Furthermore, he defines public law as the law concerning religious affairs, the priesthood, and offices of the state. Roman law conceived of the law as a series of relationships between persons and persons, persons and things, and persons and the state. Public law consisted of the latter of these three relationships. However, Roman lawyers devoted little attention to this area and instead focused largely on areas of private law. It was, however, of great importance in Teutonic society, as noted by German legal historian Otto von Guercke, who defined the Teutons as the fathers of public law. Contract law is not an example of public law. Public law refers to the area of law that governs the relationship between individuals and the state, as well as the relationships between different branches of the state. It includes constitutional law, administrative law, and criminal law. All right, young elder gang, that's all we have for you today. Stay tuned for Class 2 on Roman laws. Hit that like button, fam. Be sure to subscribe to our YouTube if you're new to the channel. Thanks for watching, peace. We out.